Trump goes to the Supreme Court of the United States. This one's on the Colorado ballot removal issue. We know that this is on appeal because what happened was at the first level, Sarah Wallace in Colorado said the 14th Amendment does not apply to Trump. Sorry. Yeah, there was an insurrection, but the removal clause in the Constitution just doesn't apply to him. And so she said he has to stay on the ballot. Then it went up to the Colorado Supreme Court, and those 4 Democrats, all appointed by Democrats, they reversed her and said, sorry, the 14th Amendment does apply to Donald Trump, and he's off the ballots, pending higher court orders. And of course, that is where we're at now. The Supreme Court is the highest court of the land, the United States Supreme Court. And so Donald Trump has submitted that to them, asking them to hear this case. We'll see what they do. But as it stands now, the removal process is being stayed. So Trump will be on the ballot pending any other further decision from the court. Now, something could happen, and the Supreme Court could also say, we're not even going to take this case. How about denied? A petition for certiorari denied. And everything that stands currently stands indefinitely. In other words, the Supreme Court Colorado decision is going to stay. So we'll see. Now, I think the Supreme Court is going to accept this because this is kind of an insane thing that's happening where secretaries of state are disenfranchising their entire state from participating in a federal election. It's kind of nuts. But what else would you expect from Crazy Eyes Griswold? Jena, the one here we'll hear from in Colorado. So let's jump into this. We've got the Trump petition to the Supreme Court. Here's the filing in the Supreme Court of the United States of America. Donald Trump versus the Anderson petitioners. These are the litigants who have been behind these efforts. And so Trump is petitioning here and the Anderson litigants are responding. This is a petition for a writ of certiorari. And you know some of these people on this list. This woman in particular, shout out to Harmeet Dillon from the Dillon Law Group. We remember her doing great work here representing the former president. Here's the question. They say the Supreme Court of Colorado held that President Trump is disqualified from holding office of the presidency because he, quote, engaged in insurrection against the Constitution, and that he did so after taking an oath as a, quote, officer of the United States. Now, the state Supreme Court ruled that the Colorado Secretary of State should not list President Trump on the ballot and also disregard any write-in votes. Now, the state Supreme Court did stay its decision pending your review, SCOTUS. And so our question to you here today from Donald Trump and his defense, in this case, his petitioner team, did the Colorado Supreme Court err in ordering President Trump to be excluded from the 2024 primary ballot? We'll get to it. So we know who the parties are, Donald Trump. We also know the Anderson litigants are these people here. Jena Griswold, Crazy Eyes. Colorado Republican GOP already submitted their petition to the Supreme Court, which we read here in a separate video. We forward ahead. Trump's team writes, it is a fundamental principle of our representative democracy that's embodied in the Constitution that the people should choose whom they please to govern them. That's us. Now, Trump, in this case, is the leading candidate for the Republican Party nomination for president. Over 74 million Americans voted for him in 2020, including more than 1.3 million voters in the state of Colorado alone. But on December 19, 2023, the wacko Supreme Court in Colorado, they ordered President Donald Trump removed from the ballot. That is a ruling that, if allowed to stand, will mark the first time in the history of this entire country that the judiciary has prevented voters from casting ballots for the leading major party presidential candidate. It's insane, obviously. Now, in our system of government of the people, by the people, and for the people, remember that? Colorado's ruling is not and cannot be correct. This court should grant cert to consider this question of paramount importance, summarily reverse the Colorado Supreme Court ruling, and return the right to vote for their candidate of choice to the voters. Now, the question of eligibility to serve as president of the United States, that's a question for Congress, not state courts to consider and decide. By considering the question of President Trump's eligibility and barring him from the ballot, the Colorado Supreme Court arrogated Congress's authority. They usurped them. Now, in addition, even if the Colorado Supreme Court could consider the challenges to Trump's eligibility, which it cannot, but even if it could, it misapplied the law. First, here's why. Trump and the presidency is not, quote, an officer of the United States. He took a different oath than the one set forth in Section 3, and the presidency is not an office under the United States. Thus, the president, Donald Trump, falls outside of the scope of the law. Now, second, the Colorado Supreme Court also erred in how it described Trump's role in the events on J6. It was not insurrection, first of all, and President Trump was no way engaged in it. And third, the proceedings in Colorado and the Supreme Court were also premature, and they violated the Electors Clause. And finally, there are many other grounds for reversal, and as many scholars have pointed out, including 3 grounds for reversal presented in the petition for certiorari filed by the Colorado GOP, which we've read through here previously. They say over the last few months, Supreme Court of the United States, Trump says, more than 60 lawsuits or administrative challenges have been filed seeking to keep Trump from appearing on the primary or the presidential ballots. The common theory behind these lawsuits and challenges, and who's funding those, right? 60 lawsuits? Where's all that money coming from? Lawyers don't work for free, man. So they want to get paid. Where is it coming from? Now, the common theory behind these lawsuits and the challenges is that President Trump is somehow disqualified from holding office under the 14th Amendment. Courts that are considering these claims, like Michigan and Minnesota, have already rejected them and acted contrary to what happened in Colorado. The court stayed its ruling in this case until January 4th, which is today, and announced that it would automatically continue if Trump sought review in this court, which they did today. The respondents in this case include 6 individuals eligible to vote, including Jena, Crazy Eyes, and they say that Section 3 establishes a constitutional limitation on who can run for president. The Anderson litigants, the people who want to remove Trump, are bringing this claim under the Colorado law, and they say that they are allowed to sue anyone charged with a duty who's about to commit a wrongful act. And they say the listing of a candidate on a ballot is a wrongful act. And they demanded, because they have a right to sue, that all of this gets cured within 5 days of the filing deadline, and they really went fast. But nothing in Colorado's law requires the secretary to evaluate these people. Instead, the Colorado statutes require a primary candidate to submit a notarized statement of intent. That form's on the website. All they got to do is affirm it. A signature line appears right here. It's it. Here's the statement of intent form. This is all that is needed. It says, I intend to run for office and I solemnly affirm I meet all the qualifications prescribed by law. That's it. A signature line appears there. Trump signs it. Donald Trump, right, with his cool signature. And Colorado law imposes no duty on the Secretary of State to verify and second guess the candidate's sworn representations. Now, the Anderson litigants, the people who want him removed, they insist that Secretary Griswold, Crazy Eyes, has a mandatory duty to enforce the Section 3 of the 14th Amendment. And they get this duty from the Secretary's oath to support the Constitution, right? So they're cobbling together this claim. So you got to do something, Crazy. Now, these also incorrectly claim that any decision to include Trump would be a breach or a neglect of duty. So if she doesn't remove him or consider this, she's in trouble. And so she, of course, acted. Now, the Anderson litigants filed their petition back on September 6th. The district court did not, however, hold a hearing within 5 days of the filing. So obviously they violated that right there, due process violation. But they scheduled it to begin on October, 54 days after the petition was filed. So it was dead on arrival. Now, the district court denied the motions to dismiss that Trump already filed, which he had already intervened in the case, and they're not complying with the law. They also denied Donald Trump's basic discovery tools, including the opportunity to depose experts or to provide potential witnesses or to compel the production of documents or to receive timely disclosures. You know, all of those basic things that we have in due process concepts in American law, gone. And they will tell us, well, there was a trial in Colorado. Why? Because Stinky Eric Swalwell came, and the compressed time frame gave Trump only about 10 days to identify and disclose his rebuttal witnesses and 18 days to disclose his rebuttal experts. The district court then held a 5-day hearing. That was Sarah B. Wallace. We covered it all here. And the findings of fact, so the judge said, this is what I think is true, rely heavily on hearsay. It's all the January 6th report. They just incorporated it. She admitted it, even though Donald Trump said that's hearsay. Obviously, that's all not relevant here. Now, the district court also relied on testimony from this guy, Peter Simi, a professor from Chapman University. He came in. He's the Trump political extremist whisperer. Okay, Mr. TDS comes in and says, I know what these people are really talking about. Insurrecting America. He said, go peacefully. He literally said, go peacefully. That means execute everyone. Well, that's wow. So he says that Trump has a history with political extremists, and he developed, there it is, coded language. Based on doublespeak. It's incredible. So even if Trump says go peacefully, we're going to march peacefully and patriotically, he's like, I guess that means murder everyone in Congress. So it's really difficult to communicate at all when they just say the things you say are murderous language. So the district court also relied on Simi's testimony, saying that Trump was intending to provoke a violent response from his audience by telling them to go peacefully. Simi conceded that he relied on public speeches, and he's a TDS whisperer, and so he probably a lot of phone calls with Liz Cheney, blah, blah, blah. They say Trump was issuing a literal call to violence. Literal. Fight's not metaphorical. He's not referring to a political fight. He wants you executed. Okay. So the district court then used his testimony and they incorporated it into their factual findings of law. Then they came to their conclusions of law. The district court, Sarah Wallace, held that the Colorado Election Code does not allow the secretary to assess this under the 14th Amendment. Now, continuing, they say, the law says you can only do it in certain areas. Now, the district court went on to hold, though, that Trump did engage in an insurrection, but they ultimately concluded that Section 3 was inapplicable because Trump never took the oath. And therefore, it held that the presidency is not an office under the United States and everything is inapplicable to Trump under the 14th Amendment. Sorry. Now, what happened was, of course, they took that up on appeal. The Anderson litigants and Donald Trump actually sought review in the Colorado Supreme Court. Trump said, first of all, I didn't engage in anything and it wasn't an insurrection at all. So he wanted portions of that reversed as well. But the Colorado Supreme Court just reversed almost everybody, says here, reversed, Trump goes off the ballot. Supreme Court, in their ruling, which we also read, first addressed whether the Anderson litigants could review and bring their claims. Of course, they found that they did. The court reached this conclusion by saying only qualified candidates can participate in the primary. Now, this is a restriction only on the political parties, and it does not require or even allow Crazy Eyes Griswold or the courts to purge individual candidates. Now, no one contests that the Colorado Republican Party had at least one presidential candidate who is indisputably entitled to be on there. That is all that is needed to show. All. Okay, this is kind of technical stuff, but in other words, they don't have even the mechanical rights in the statute to consider these other things. Colorado Supreme Court also held that a presidential candidate is not qualified, and he must be qualified before his name is added. Now, the court did not consider the possibility that a presidential candidate who's currently disqualified might become qualified. For example, somebody who's 34 could be 35, or somebody could reach the 14-year residency mark, or a candidate currently disqualified under Section 3 can seek congressional removal of disability, right? So that's a possibility too. So Trump could say, oh, if I am disabled, I want Congress to override that, right? Because the provision, the statute provides for that. The amendment, the 14th, provides for that. The court also dismissed out of hand that Trump's argument that Section 3 bars individuals from office and not running from office. And so having concluded that they could proceed, then the state Supreme Court actually moved on to the merits, right? All that was kind of technical nonsense. When we got there, it rejected Trump's due process challenge, said no, that, everything was happening here perfectly. The trial was okay. It also held that disqualification imposed by Section 3 is self-executing, automatically attaches. You don't need Congress to do anything. And it rejected Trump's argument that this was a political question. And finally, the Supreme Court also reversed, said that Section 3 is applicable, that the president is an officer of the United States, and the presidency is an office, and that Trump engaged in an insurrection, rejected all of the other defenses, said that he needs to go off the ballot. Anybody who writes his name in, you're done too. Now, the judges, also 3 of them wrote dissenting opinions, and they made very good arguments. Justice Sommore also argued that they violated due process, discovery was denied, they rushed the proceedings, they based their factual findings on congressional hearsay, and their experts were of dubious reliability, largely because they have TDS. So they say, all right, all of that is the backdrop. Now, that was obviously a lot of procedural history. And they say, so given that this was all a disaster, this is what we're asking for now. Colorado Supreme Court has no authority, they tell SCOTUS, to deny President Trump access to the ballot. And by doing so, they have usurped congressional authority and misinterpreted and misapplied the text of the Constitution. The issues presented in this position are of exceptional importance, Supreme Court, and they urgently require your prompt resolution, saying the question presented in this petition are of utmost importance. President Trump is the leading candidate for the nomination of the President of the United States. In 2020, he got more than 74 million votes and more than 1.3 million votes in Colorado alone to be reelected as president. And thus the Colorado Supreme Court decision would unconstitutionally disenfranchise millions of voters in Colorado. And if you do it, it's likely going to be used as a template to disenfranchise tens of millions of voters nationwide. If you do it here, they're going to try it everywhere. And they're going to say the Supreme Court gives them permission to do it. Indeed, the Maine Secretary of State, in an administrative proceeding, has already used Colorado, okay, the domino effect we talk about, already picked the Colorado decision and strucken Trump from that state ballot. Now, President Trump has appealed over there as well, saying whenever there is a disputed question of presidential qualifications, SCOTUS, we have to let Congress decide what to do about it. Now, not all courts are suited for resolution of these complex issues. Congress, they say, not a state court, is the proper body to resolve questions about an eligible candidate. First, why? Well, the Constitution provides a role for Congress in resolving disputed presidential elections. For example, the Constitution specifically says, if the president-elect shall have failed to qualify, then the vice president shall act as the president until a president shall have qualified. And if there's a problem, Congress may provide a law wherein neither president-elect nor a vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one who is to act shall be selected accordingly. Now, they say here, the 14th Amendment itself embodies a clear textual commitment to Congress. So Congress deals with those issues. Congress deals with these issues. Congress, they wrote in Section 5 of the 14th Amendment, it says Congress, quote, shall have the power to enforce this article. There's no similar commitment to any other state courts. They don't ever say, we'll just give it to the states. Why don't we let Crazy Eyes Griswold, Secretary of Colorado, just decide? That's not in there. Considering the constitutional role for Congress, it's little surprise that every court except Colorado that has addressed this question has determined that the question is non-justiciable. It's reserved to Congress. In other words, this is not a question that you can even sue over. Take it to Congress. Indeed, every federal court that addressed this issue, whether Barack Obama was eligible, remember that that regarding the eligibility of Barack Obama and John McCain and Ted Cruz, who some people say is the Zodiac killer. I don't know, maybe. That the issue was for Congress and not the federal courts. Okay, we've already said other people are ineligible with John McCain and everybody. They say, well, it's not our problem. It would be, says Trump, beyond absurd, particularly in light of the 14th Amendment's enlargement of federal authority, that this issue would be non-justiciable by the federal courts, yet properly heard and decided by courts in all 51 jurisdictions. The election of a president with the United States is a national matter with national implications that arises solely under the federal Constitution and does not implicate the inherent or the retained authority of the states. Now, in the absence of any enforcement legislation, Section 5 gives it over to Congress. But the Colorado Republican Committee, they've argued that Section 3 is not self-executing, and this court needs to answer that alone. Even if Section 3 does not require enforcement legislation to have effect, the lack of such legislation deprives the courts of judicially manageable standards. So in other words, if you're going to say Congress doesn't govern this and you're going to give it to the courts have no idea how to handle this, obviously. There's no safeguards, procedural mechanisms by which we can ensure that these are done appropriately. Procedurally, Section 3 is silent. There's no guidance there. Do we have a jury? Do we have a judge? Do we have a lone state election crazy eyes make decisions, make factual determinations? It's likewise silent. What's the standard of review? Is this preponderance of the evidence or beyond a reasonable doubt or clear and convincing evidence? What's the standard? Creating the prospect that some courts can just do whatever they want. Others will adopt preponderance. Others clear and convincing. Others may be criminal. Similarly, states have different approaches to voter standings. As a result, a voter in one state may be able to challenge somebody there while another state cannot. And substantively, terms like engage and insurrection, those are wild terms, varying standards of those. How do you even define that language? So resolving these conflicts requires making policy, and they have to compete amongst political and policy decisions. That is what Congress does, not the courts. Now, moreover, they say the result of the divergent standards and all the various determinations is particularly problematic when we do this during a presidential election. This court has already recognized back in 1983 that in the context of presidential elections, state-imposed restrictions implicate uniquely important national interests because the vice president and the president impact all the nation. By purporting to determine this, the Colorado Supreme Court overstepped their power and they usurped the power from Congress. Now we get into the meat and potatoes of the application of the 14th Amendment, and they say this is Colorado Ballot's removal case at the Supreme Court. Trump's defense says Section 3 is inapplicable. Same thing that Sarah Wallace, the district judge, said. Section 3 begins with no person shall be a senator who has insurrected the country, okay? It lists offices in there. It says it does not list the presidency. Look at this. Anyone, no person shall be a senator, representative, elector of the president, not the president, the vice president or elector, or hold any office, civil, military, or any other thing. Doesn't say the presidency because the people can decide that. It does not list the presidency. It lists it highest to lowest. And so any office, civil, or military, it's like a catch-all. They didn't like insert the presidency in there. Thus, to find that Section 3 includes the presidency, one must conclude that the drafters decided to bury the most visible and prominent national office in some catch-all term that includes low-ranking military officers. Now, this reading defies common sense and it's obviously incorrect. Now, similarly, the disqualification can apply only to those who have previously taken an oath as a member of Congress or as an officer. Now, as we know, Donald Trump, it is undisputed that President Trump never took an oath as a member of Congress or a state legislator or as a state executive or a judicial officer, so it does not apply to him. And lastly, Section 3 cannot apply to Trump unless the president is an officer of the United States. But if he is an officer, they say the Constitution makes clear the president is not an officer. The phrase officer of the United States appears in 3 provisions apart from Section 3, and in each of these provisions, the president is literally excluded. The Appointments Clause requires the president, who is the root power, to appoint ambassadors and to appoint all other officers of the United States. The officers of the United States are appointed by the president, which is the root power of the country. Here, the president does not and cannot appoint or commission himself. He cannot qualify as an officer of the United States when the Constitution draws a distinction between officers and the president who appoints them. It is a legal clarification, and it's logical also. The impeachment, like all of the power is vested in that executive president. The impeachment clause further confirms that the president is not an officer. It says the president, vice president, and all civil officers of the United States, it disambiguated them, shall be removed from office on impeachment for and conviction of high crimes and treason. Now, the clause causes the president and the vice president to be separate. There is no basis for separating them out if they are also civil officers. Otherwise, they would just say all civil officers. And there's also the textual requirement that Section 3 applies only to those who took an oath to support the Constitution. Constitution. That's an oath required by representatives, state legislatures, and others. The president swears a different oath. It's to preserve, protect, and defend the Constitution. Support is nowhere to be found by design. The argument that it's the same is conflating the two oaths. It's a clear contradiction because the president was not understood to be included as an officer of the United States. Now, the Colorado Supreme Court didn't care about any of that. They made no attempt to explain how, quote, officers of the United States can include a president when this phrase excludes the president everywhere it appears in the Constitution. The court should grant cert in this case, Supreme Court, because Trump never swore an oath as an officer of the United States. Continuing, arguing now that Trump also did not engage in an insurrection. Ridiculous. They say first, the events of January 6th were not an insurrection at all in the first place. Insurrection, as understood at the time of the passage of the 14th, meant taking up arms and waging war upon the United States. You know, because we had just come out of the Civil War. When considered in the context of the time, that makes sense. Why? Because we had a horrific civil war. 600,000 people died, and the very survival of the nation was in doubt. So focusing on war making was the logical result. But now, by contrast, the United States has a long history of political protests that have turned violent. For example, in the Summer of Love 2020 that Kamala was supporting by getting protesters bailed out of Minneapolis, violent protesters targeted federal courthouse in Portland for over 50 days. They repeatedly assaulted federal officers. They set fire to courthouse, all in support of a purported political agenda, opposing the authority of the United States. U.S. Homeland Security even issued a report about that. Now, 50 days, onslaught attacks, a pure political agenda, organized, federal officers repeatedly assaulted, property damage day in and day out. Is that an insurrection? It's closer to one, but I would still say no, obviously not, right? It's an onslaught protest, should have been dealt with, but are they going to take over the country? This is waging political war? I would say no, but it's much more substantial than anything that happened on January 6th. And by the way, during the Summer of Love, they also torched the 3rd precinct in Minneapolis. It was billions of dollars of damages, not under 3 million that took place in the Capitol building. Billions. Now, in the context of the history of violent American protests, January 6th was not an insurrection, and thus no justification for this at all. Moreover, nothing that Trump did was engaged in an insurrection. He never told his supporters to enter the Capitol. He never told them to do anything at his speech at the Ellipse or in his statements elsewhere. To the contrary, his only explicit instructions, the only thing that he ever said, called for protesting peacefully and patriotically. What else did he say? To support our Capitol Police and law enforcement. He said to stay peaceful and to remain peaceful. But I guess all that is coded language that means execute Order 66 and eliminate Congress. Got it. So the Colorado Supreme Court, they then faulted Trump for not responding. They said he should have responded with alacrity when he learned the Capitol had been breached. Trump should have just opened up a live stream. Please stop it. And acted like, you know, hysterical Liz Cheney would have acted. That's not his prerogative. Okay, you're not the president. You don't get to decide how he responds to that. That is substituting your discretion for his. That is exactly what you're not supposed to do under Marbury, right? The court is not supposed to substitute and judge the president's discretion. Even, however, the Colorado Supreme Court conceded that not acting does not constitute engagement, they had to admit. And they said here, the court should reverse because they said that Trump's speech would also be protected. And the state testimony relying on TDS Professor Simi also deferred to his fact finding, and constitutional speech should not turn, and the protections should not turn on opinions from sociology professors like that guy. They say Colorado also violated the Electors Clause, telling us that the Electors Clause requires states to appoint electors in a manner that's consistent with the state legislatures. The Colorado Supreme Court ruling violates that. Why? Because the legislature allows the state judiciary to intervene and decide ballot disputes, but they don't have the authority to do that. Secretary Griswold cannot neglect her duty, any duty, which includes this. The Colorado Supreme Court tried to concoct a wrongful act by claiming that the secretary could address this stuff when it comes before her, but they then somehow managed to transform this statutory language so that Griswold would then violate the law, right? Griswold would violate the law if she failed to act. So basically they just perverted and adjusted the statutes to get whatever they wanted done. They say Section 3, in concluding, this is to the Supreme Court of the United States, saying Section 3 also prohibits individuals only from holding office, not running for office. Does not prevent anyone running or from being elected because Congress can remove it. Congress can remove the disability. So if you're elected, maybe they don't take office, but they're elected to the office and Congress can remove it. So that basis alone, okay, just because there's a logical possibility that that could happen means that if you remove Trump, you are now violating those provisions. You're violating that possibility. Colorado claimed that it has no less authority to exclude Trump than a 28-year-old. But that's wrong. Congress has no authority to add additional qualifications to the Constitution, residency, or natural-born citizenship clause. Forcing Trump to prove that he is not disqualified before appearing on the ballot adds a new extra-constitutional requirement. But the case U.S. term limits renders the states powerless. The states cannot alter the constitutional qualifications to this. Even the term limit dissenters acknowledge states are forbidden from prescribing qualifications to the presidency. That is for Congress to decide. The president, unlike members of Congress, represents and is elected by the entire nation, and allowing each of the 51 jurisdictions who are all going to vote for the man to enforce their own qualifications is going to lead to national bedlam and voter confusion. And in what Colorado did is they added a new qualification. It's no different from the state enforcing some other new requirements, and they're not allowed to do that. So in each of these situations, a state that violates the rules by altering their qualifications is not allowed to do that. So you see Harmeet Dillon and others, Scott Gessler, David Warrington, and many others submitted this to the Supreme Court, writing in conclusion, the petition for a writ of certiorari to the United States Supreme Court deciding this Colorado Supreme Court ballot removal issue should accept the petition and reverse what they did in Colorado. Put Trump back on the ballot, say all of this was nonsense, no insurrection, 14th Amendment doesn't apply, Trump didn't engage in anything, and this is not something that secretaries of state can decide on their own. So we'll be here continuing to cover the replies. Of course, the Colorado lawyers will be filing their response to that, but this is what they have been saying when they've been making their rounds on the media. This is Eric Olson. He's appearing representing the plaintiffs in Colorado, and he is now responding to Trump's appeal, the one that we just read, which is extremely solid, that has nice structure to it, refutes all of the points, and I think the most obvious way possible. This is what his response is to what we just saw.
I think that any of the arguments that they're making here, in your view, are valid.
They're arguments we've all seen before and have been rejected by the courts. He claims here, I guess the one new thing is he claims for the first time that no court, not even the United States Supreme Court, can determine whether someone engaged in an insurrection, and that he's above any judicial determination of what he did leading up to and on January 6th. That's just not the law, and we're confident the Supreme Court will reject
Did you read
that claim.
We just read it. I didn't read
what
that.
I'm interested in, part of the argument here, and this is something that we have gone round and round about when talking about this issue with legal experts, constitutional law experts, and it's an argument that, as the Trump legal team says here, even if the Supreme Court in Colorado could consider challenges to Trump's eligibility, that they misapplied the law because the president is not an officer of the United States and never took an oath as one, and that the presidency is not an office under the U.S.
Caitlin, that argument has been raised several times. Overwhelming majority of scholars reject it, and properly so, because to give that argument effect would mean that Jefferson Davis, who led the Confederacy, led the Civil War against the United States, could have become its president shortly thereafter. There's no indication in historical record that that's what anyone intended. It was a broad ban applying to all those who held office and were officers, and the president was and is both.
So even as they kind of point out that there are other parts in the Constitution where it does lay out officers of the United States and it lists the presidency separately, you don't think that it's separate, even though it's referenced separately in other parts of the Constitution?
No, we think that the Colorado Supreme Court thoroughly addressed this question and properly held that Constitution applies to everyone. And the purpose of Section 3 of the 14th Amendment was to prevent those that took an oath to support our Constitution and then engaged in insurrection from holding office again. And there is no reason whatsoever to think that they left out the most powerful person in our democracy, the president, from that prohibition. Again, Jefferson Davis could become president under this theory. There's no basis in law or history.
If he ran and the country would have voted for him.
When it comes to this and the questions of, you look back at history and what it tells you, but when we're looking ahead to what the Supreme Court is going to do here, do you think that they will take this case up? And if so, are you still hoping to get a decision as soon as February 11th?
We certainly expect they will take the case. Every party to the case has urged them to take it. We disagree a little about what questions they should take, but every party has urged them to take it. And if they don't take this one, there's more behind. There's ones coming from Maine and perhaps other states.
Of course there are.
So the court will need
Full
this
force
case
onslaught.
quickly. This is an ideal vehicle to do it. As to whether they'll decide it by February 11th, voters in Colorado receive their ballots on February 12th. We've asked the court to work quickly here to issue a briefing schedule and argument schedule that allows them to complete a decision by February 11th so that those voters in Colorado and elsewhere on Super Tuesday have the benefit of knowing whether Donald Trump is disqualified.
Wild. Isn't that wild? So in other words, Trump would be on the ballot. You could go fill in the bubble for him in your primary, our Colorado friends out there. And then the court could come back down, right? Theoretically, I don't think it's going to happen. And then you would vote for him and they would just delete those votes. Gone. Just deleted. No, he's not qualified. Sorry, he can't be on there. And then they'll turn around and call us insurrectionists in America as they're disenfranchising every single one of those votes. They're stealing the election. I mean, they're actually trying to steal it openly using the courts. Wild.
If they do take it, how tough do you think the fight's going to be for your side?
I think this court has shown a willingness to step aside from sort of the partisan frame on these hard issues that are important to our democracy. We're optimistic that, as did the Colorado Supreme Court, that when you look closely at the legal arguments and evidence presented here, there really isn't a close case here. Donald Trump engaged in an insurrection against the Constitution, and therefore, under the Constitution, he cannot be our president again.
Incredible. So these are the people fighting for democracy by taking away your right to vote for somebody in a democratic process, in a democratic election. And they will sit there with their dead eyes and just tell us that this is in our own interests because Trump has been disqualified. So here's another person with some crazy eyes. Crazy Eyes Griswold is back, and she showed up here. You can just see this woman has another level to this. She posted this on her own account. It says the American people deserve to know whether a president can engage in insurrection and then return to office. And she just has, some fake hearing where they present facts from Liz Cheney, literally gobble up her report. And that is the determination about whether someone has engaged in insurrection. Here's Jena on MSNBC doing her thing.
Frankly, the American people deserve to know whether a president can engage in insurrection and then be qualified once again to hold that office.
In what you see in Donald Trump's petition to the Supreme Court, is there anything there in their petition that shapes your view of this case as opposed to the Colorado Supreme Court's view of the case?
I would qualify it as more of the same to a large extent lies that we've heard since 2020. Donald Trump is trying to argue he did not incite an insurrection. Well, 2 Colorado courts at this point have determined that he did. And then Trump goes on to argue that even if he did incite the insurrection, well, the Constitution doesn't apply to him. I don't think that's right. I don't think that there's some get out of jail free card for the presidency that allows Donald Trump to escape scrutiny of the laws of the land and the Constitution. So I do think it's important for the United States Supreme Court to act quickly, even if that action is determining that they will not review the case. That, in effect, would basically put Colorado Supreme Court's case in full power and would disqualify the former president.
All right, so same talking points that you hear. No president, get out of jail free card. All that kind of stuff. No one's above the law, engaged in insurrection, 2 courts have found, blah, blah, blah. Same stuff. These people, you can feel their rage, can't you? You can read it in their eyeballs. Like, they're not apolitical people. They are not people who are just trying to make sure that they're operating the levers of the legal system to get qualified candidates on them. Not at all. They are partisan hacks who absolutely detest Donald Trump, and they are on a political mission to get him off the ballot. They're trying to steal the country right in front of us, like right now, by saying you can't even vote for the guy. And even if they lose, which I also have my concerns about, the Supreme Court, I don't think they're going to do this, but they could say it's a states' right issue. Maybe, something they would get Thomas to recuse. We know Roberts is very squishy. Now we deal with this like 4-4 situation. I don't know, but it's beside the point. The point is these people's intention, everything that they're doing, they're working to do is to steal the election right now away from you. You don't even get to vote. And we cannot forget that. Okay. When this small issue moves on, hopefully the Supreme Court settles it, but that's what they're doing. And they run the elections. So if Trump gets on the ballot, she's still running it. She's the Secretary of State. So all of the things, all the people that are working for her, all of the mechanics are still being operated under the umbrella of deranged, crazy eyes psycho. So, it's not good. It's not good. We can't lose sight of that. So, all right. So that's Jena Griswold, aka Crazy Eyes. Let's hear from some of Trump's people. This is a former Trump attorney who was brought on to respond to some of this with Tapper. Here is Tapper asking Mr. Tim Parlatore about this.
To appeal that Colorado Supreme Court decision to ban him from the ballot, because frankly, I thought that they were going to move more quickly.
Why would they move fast?
I would have expected them to move more quickly too. I don't have any specific knowledge other than, as you know, one of the reasons why I left that team is...
I would say that you would delay it so that you don't have an opportunity to get him off the ballots, right? There's a stay in place right now. So there's no rush. Just leave the status quo. He's going to be on the ballots right now. So, okay. You want to get as close as you can until the actual day of the vote. A lot less likely to remove him if there is no decision than if there is a decision. So there's no rush.
Interference, from other people. So I could imagine that, this was definitely litigation by committee of going back and forth with drafts. And I I mean, Dave Warrington, who filed the brief, is a very smart lawyer. I would expect him to do good work and do it fast, but if he's being interfered with by others, then that would delay it.
Who are the others that interfere?
No, come on.
Well, in my experience, it was people related to the campaign, like Boris Epstein.
Yeah. Do you think the U.S. Supreme Court is going to take this up?
I do. It's a situation where you have a significant split between the states of an issue that really does have vital national importance as to, whether, people in different states are going to be given the same choice as to who they're allowed to vote for president. So I think that, if there is ever a case that falls squarely within the mission of the Supreme Court to solve these issues, this is it. So I can't imagine them rejecting it.
Yeah, it's a big problem. If they decline this, then Colorado is going to just say, okay, success, right? We're done. And other states will follow suit. There will be the floodgates of ballot removal lawsuits all over the place, and they'll just rely on Colorado. It would be total bedlam, which is why I think that there's no way they can allow that to happen. This is Byron Donalds also responding to this. Of course, he says, here's my message to Jena Bellows. Jena is over in Maine. She's the other one who just removed Trump because Colorado. Like, my friend Crazy Eyes Jena did it, so I can do it too. Yay. And says, hey, my message to Jena. You're going to lose in court, Byron says. You're turning people away. This is going to backfire and worsen things. And you also exposed your radicalism. Again, another Jena who's going to run the election. So she's openly trying to get Trump removed. And if she doesn't get him removed, she's the referee. She's the person who is now going to be governing how the elections are covered. All of it, all of the mechanics are governed by this person. So do you think it's going to be a fair election in Maine? It says these people don't care about laws or institutions at all. They don't care at all. They only care about winning. Byron is exactly right. Says we must rid our system of this rot. He's right.
My message overall is you're going to lose anyway. But when you do stupid stuff like this, what you're really doing is you're turning off independent voters and even some of those soft Democrats, those conservative Democrats. Yes, they exist in the country. They're voters. They're not electeds, but they're conservative leaning and they're also Democrat registered voters. You start turning people off because what you're saying is that you would rather just disenfranchise a segment of the country. You would rather just remove political opposition as opposed to actually having the political process take its natural course. So I think this is going to backfire. It's already backfired and it's only going to get worse. But this is really proof of the radicalism that is in the Democrat Party. I mean, we're not talking about political disagreements or, somebody who's very liberal or somebody who's very conservative. These are radicals, people who don't care about the rule of law. They don't care about our institutions. They only care about their agenda and winning elections by any means necessary. That is the rot in our country, and we got to get rid of it.
And they'll tell us they're doing it for us to save American democracy because they can't let an insurrectionist on there. Well, if they are really concerned that he's an insurrectionist and everybody knows he's an insurrectionist, then why don't we just let the people decide? Because the people don't think that. They think that in their deluded mental state. So we're going to be here continuing to cover this, my friends. Trump is submitting his petition. The Colorado people are going to be submitting their reply. We'll see if the Supreme Court picks it up. Thank you for subscribing wherever it is you're watching this. Thanks for also checking out watcherlodge.com, our newest project. We have our fitness challenge underway right now. You can sign up all the way through January 5th. Just go over there, check out the Lodge, the fitness challenge. One good thing every day for 31 days for yourself, something health related. And it can be, hard or it can be easy. But come and join us. We're giving away some prizes, giving away some scholarships, and you have up until January 5th to sign up. Come and join us. We have a lot of fun, great comments, people sharing some good fitness advice at watcherlodge.com. Of course, we're going to be here covering all of the Trump saga. Thank you for subscribing and sharing this with a friend or family member, and we'll look forward to seeing you back here on the next one.